Awesome. Okay, thanks.
I suppose when I stay, I had a fancy there. Let me do. There any benefits?
There's no reason.
Each day. I can go back out. Okay, my name is Suzanne Harding, the chair of the electoral board of Wheatland Township. Named by Chief Judge Daniel Kennedy of the Will County Court as a public member of the electoral board to section 10-9 of the election code. As a chair, I called this meeting of the election board to order on Tuesday, January 14th, 2025 at 1 p.m. I'd like to begin with the roll call of members of the electoral board. Member Anita? Linsky? Yes, here. Member Colleen Rokas? Here. And Chair, myself, Suzanne Hart, present. I would like to start with, I will now entertain a motion to open the hearing on case number 24 TOEB1. Pigeon, I'm going to say this incorrectly, versus Brian Evans.
I make a motion.
Second. Okay, motion passes. We'll now consider case. Yes, sorry.
You have to vote.
Yes. Case number 24 TOEB1. How am I saying his name? Does anyone know?
Pigeon.
Pigeon versus Brian Evans. Motion passes. We'll now consider case.
No, we have to vote.
Oh, that we just did.
No, we just
Moving
motion.
in a second.
Yeah,
Okay. I entertain a motion.
we did that. So now just call us.
Motion passes. We'll now consider case 24 TOEB.
I
First,
We
I'd
all
like
have
to
to vote.
identify some of the board exhibits for the record.
Right.
Nomination papers.
We have a motion and a second, but they didn't vote on the motion. So say
Motion.
all those in
All those in
favor.
favor?
Aye.
Now motion passes. Thanks.
Sorry. Okay, now we will consider case number 24 TOEB1. First, I would like to identify some of the board exhibits for the record. The nomination papers for candidates will be marked as Exhibit 1. The objectors petitions will be marked as Exhibit 2. The call of the election board and other meeting notices and agendas will be marked as Exhibit 3. The certified receipts of service in the candidates will be marked as Exhibit 4. Objectors' waiver of service will be marked as Exhibit 5. The appearance of Mr. Morton on behalf of the objector will be marked as Exhibit 6. The appearance of Mr. Coltman on behalf of all and Mr. Edmonds will be on behalf of the candidates will be marked as Exhibit 7. I'd ask for a motion to enter these documents in the record. A motion. Second. Motion carries. Ask the council if they have any objections. You want to do roll call?
Yes.
Okay. No.
Just call for all. Yeah, I support it.
All right,
let's move on.
let's. move this. Okay. We understand that council and candidates and objectors have filed various motions and responses. I'd like to mark candidates' motion to dismiss and notice the filing based on the time stamping of the objection of Exhibit 8. And objector's response and notice of filing as Exhibit 9. I'd like to mark candidate's motion relating to the clerk's compliance with section 10.8 and notice the filing as Exhibit 10. I'd like to mark objector's response and notice of filing as Exhibit 11. I'd like to mark objector's subpoenas and notice of filing as Exhibit 12 and 13 and mark objector's request for production of documents and notice of filing as Exhibit 14. I'd like to mark candidate's motion to squash objector's discovery and notice of filing as Exhibit 15. And candidate's motions to dismiss for failure to abide by the rules and notice of filing exhibit 16. Council to be either the party to file any other documents.
At this time.
I will entertain a motion to enter these documents into the record. Motion,
I second that.
third. Okay, motion carries.
All those in
All
favor?
those in favor, we just, aye.
I support it.
Any objection from the council? No, there's-
I didn't actually hear what exhibit 13 was. What was 13?
Exhibit 13 is 12 and 13 are the subpoenas.
Okay, separate.
So each
Okay.
subpoena was marked separately.
Which is which? Does it?
Sure. Exhibit 12 is the Mitchell subpoena and exhibit 13 is the Lowry subpoena.
Lottery.
Lowry.
Okay, so the first motion to dismiss is based on questions raised by the timestamp on the objection. This is your motion, Mr. Copman. Do you have
Yes.
any argument on this issue in addition to the arguments raised in your motion?
Yeah, I would like to add that, you'll note on the objector's petition, the original which you have there, I'd ask you to take a look at it. There is no machine timestamp on there. However, if you look at the candidates' filings, there is a machine timestamp on that. It's very faint, it's difficult to read. And I'd like to show to the board a document that was filed on January 8th. There were This was filed with the township clerk's office. And these are Mr. Dorada's,
I'm sorry, what does this have to do with what we're talking about right now?
what we're talking about right now is the timestamp. That's what I'm talking about.
Okay, but this is a separate issue though, that you're trying to bring in regarding one of the other parts of the objection. What you're alleging in your petition is that the objector's petition was not correctly dated timestamped. It doesn't matter what other documents have been date stamped a different way. What matters is the objector's petition.
It goes to the custom and practice of the township clerk's office. This document was filed on January 8th. It has a timestamp on it. And this is relevant to a portion of their objection, which we'll discuss later, presumably. But I just want the board to take note, you have the right to take judicial notice. This is a filed document, it's officially with the township clerk's office. It has a timestamp on it.
This is not what you're holding though. You're holding a copy of
It's a
something.
copy of it, that's correct. And I'm sure the original is in the clerk's office, if somebody would like to retrieve it. That would be fine with me and have them take a look at it. But the whole point of the.
And just for the
I'm bringing
record,
this
I'll
up.
let you finish, but just for the record, I'm objecting to the present.
I appreciate being able to see the actual physical of what we're talking about because we're just reading about
Copy.
it. There it is. So
I'm not objecting to that.
Yeah.
I'm objecting to other documents that haven't been brought up before being presented to
Okay.
you. Sorry.
May I present this to the board for their review?
please.
And then again, that is a copy. It's a photograph, but the point is that I'm concerned about the compliance with the custom and practice within the clerk's office. It appears to be that the custom and practice is a timestamp using a machine. That did not happen in this case with the objector's petition. And because of that, it calls into question the integrity of the process. Process is there to give assurance. And when you have a rote process that is followed routinely, and when it's not followed in one instant, it makes you wonder if there's something afoul or amiss. I suggest that in this particular case, as provided in my written motion, it calls into question the integrity of the filing. Did it really occur on December 23rd? Maybe it occurred on December 24th and the machine couldn't be rolled back to show December 23rd. I don't know, but something is odd when it doesn't follow the ordinary custom and practice of the process, calls into question the integrity of the filing. And that's the basis for our motion to dismiss. And I appreciate your consideration. Thank you.
If I may.
Okay, I was just gonna ask for either parties or any other docs, so you have. Clarification or?
I have a response to what he was just arguing. As we lay out in the motion, it is date stamped. All that the statute requires is that the date and the date and times be entered onto the objector's petition. It's handwritten rather than a stamp, but the statute doesn't require a stamp. It requires that the date and the time be entered on the document. The candidate's attorney has not presented any evidence that that did not occur, that it is not true. All he's presented is speculation that it might not be true. He says, I don't know what happened. All we do know is what's presented on the document. On the document, it says it was timely filed on that day at that time. No requirement of the election code has been violated. The customs and practices of the township clerk's office, what's been done on other documents, doesn't matter what's done in this document as long as the statute has been adhered to. There's nothing that says the date and time need to be affixed in the same manner on the objector's petition as on the candidate's nomination papers. As long as the date and time are there, which they clearly are in the document that you have in front of you, that's all that matters.
I have a question. So is there, and again, I know I'm trying to act like I am an attorney or a judge, not, I just live on a TV, but is there case law that you have to have the timestamp, I mean, just.
The law says you are required to put the timestamp on the document. The law does not say it needs to be done in any particular way. So the law does not say it cannot be handwritten. The law does not say it has to be timestamped. What Mr. Copeman, I believe, is it Copeman or Copman?
It's Copeman.
Copeman, thank you. Is saying is that not so much that it's illegal that it was handwritten, but that because one was handwritten and another was using a machine, that raises an issue about whether or not
The
it was
integrity of the
actually-
process.
Exactly.
The integrity of the process.
Exactly. And this, under the board rules, this is what we call a preliminary motion. And what that means is that the motion is based on the material that's in front of the board. Mr. Copeman has the opportunity to develop evidence that shows that the document was in fact filed late. And that's a legitimate argument that the document was not filed on time. But what he's asking you to do is to say that it wasn't filed on time just because it is handwritten, and that's assuming that Mr. Green went and backdated the filing. So again, my recommendation would be that as a preliminary motion, I don't think this is sufficient because he hasn't proven that it was filed late, but that he certainly would have the opportunity to obtain evidence that the material was filed late and present that evidence to the board at the hearing that we're going to have later.
So that the timestamp didn't work when the objection was filed, right? Please, I'm just kind of putting that out there for myself mostly, for my rest of the elect.
So we don't know
And
that. We don't know that it's, we just know that.
we just know, right? But then it, right, so if it worked after. So it didn't work that day, but then it worked
I don't think anybody's
after.
saying it didn't work. You just
But again,
Understand. Oh, so it
what I'm
doesn't, so
trying
the
to say
law
is this is a
doesn't say.
preliminary motion, so we only rely on
Right.
what is in
Okay.
the documents. So the question of whether or not the machine was working, whether or not there's videotape of people coming into the building to file it, whether or not there's testimony that someone saw someone coming in on Tuesday with the document. All of that is fair game for either of the council to bring before the board at an evidentiary hearing. But as a preliminary motion, you know, my recommendation would be that because you don't know if the machine was broken, because you don't know what happened on Monday, the 24th or the 23rd, that needs to be developed more for the board to come to a decision that the objection was not filed on time. And so for this purpose, I would recommend that the board deny the motion, but not deny that council has the opportunity to present evidence that the document was filed late at the evidentiary hearing. That's my recommendation.
May I be heard?
Yes,
Just two things. First of all, Chairman Hart, you asked what the law says. The law says in the case of nomination papers, the local election official shall note the day and hour upon which the objector's petition is filed. That's straight out of the statute. Doesn't say it has to be by a machine. My only point is the clerk's office apparently routinely accepts things and files them and does it by stamping them with the machine. That did not happen in this case. That's an aberration. That calls into question its validity. Having said that, your board of counsel has suggested that I can present evidence. The problem is we presented a FOIA last week asking for that camera footage, and we have not received it, and it's
Oh,
well
I
beyond
can,
5 days.
can I talk?
So we,
You are an adjudicator here. You are not a
All right,
witness, so you cannot, but
Okay.
so to
sorry.
suggest
I
that
got
we
lots to
could,
say, but
to suggest that we can present evidence, we can't because we haven't gotten what we've asked for. So I
we
just want
will
that
make sure
for the
that
record.
you have the due process right to get that before the evidentiary hearing. We will make sure of that.
We're not doing the evidentiary hearing today.
That's possible. It's up to the board to decide, but it depends if the board grants any motion for discovery, then counsel for the objector would have the opportunity to get that discovery before we have the evidentiary hearing. But again, that's completely up to the board. And if you have witnesses and evidence here today that you'd like to present, there's no reason that we can't do that for the benefit of your witnesses if the board wishes.
If I maybe heard as well. The issue that he is alleging is that something might not have been done properly, but he's presented no allegations of actual wrongdoing, whether or not he has the evidence in front of him. If he thought there was something wrong, that it was filed late, he could have alleged that. If he thought that it was that someone had done anything improper, he would have alleged it and then could have tried to find evidence to support that, but he did not do that. And I would, take issue with the idea that there could be further discovery on this preliminary motion. The preliminary motion
Correct.
is up today. This is the time to decide on the preliminary motion. Other evidence regarding this would not be for the evidentiary hearing, which is just on the objector's petition.
And if I allege something like that, I'd be in violation of my ethical obligations as an attorney. I cannot make an allegation if I don't have any evidence in support of it. So for counsel to suggest, well, if you thought that's what happened, you could have said that. No, I can't. I don't have the evidence. I don't have anything in the clerk's office. I can't make those allegations, unlike the objector's petition, which apparently makes allegations without support.
You also don't have any basis for making the allegation. If you had a basis for alleging it,
Okay,
you could, but you don't.
counsel, speak to the board, not
I know, I'm
Your
right
opposing
here.
counsel.
We're right here.
the board is your audience. I'm going to recommend that you deny the motion without prejudice to allow Mr. Copeman to introduce any evidence in the future that he might obtain that the objection was filed late.
Make a motion to do that. I
second.
can't repeat it all.
Third, all in favor?
Yes, I.
Just for the record, I object to that. I want to make sure that I preserve it. Thank you. Yes.
What are you objecting to? I'm sorry.
The ability to bring forth evidence under preliminary motion.
Second motion? Did you miss it based on questions raised by the clerk's notice of the objection to candidates? This is your motion, Mr. Copeman.
Yes.
Do you have any argument on the issue in addition to those raised in your motion?
Anything in addition? No, I would just point out that the statute says that the local, in the case of nominate excuse me, where an objection is filed, the local election official shall note the day and hour upon the paperwork, correct? And shall not later than 12 noon on the second business day after receipt of the petition, transmit a copy by registered mail or received personal delivery of the objector's petition to the candidate whose paperwork has been objected to. Statute requires that to happen. That did not happen in this case. The objector's petition was not sent within, on or before noon of the second business day after the objector's petition was filed. Because that was not done, I suggest that this court does not have, or I'm sorry, this board does not have jurisdiction over the matter and ask that it be dismissed.
Thank you. Yes, just to reinforce what has been stated in our response, there is clear case law on this issue. In Shipley v. Stevenson County Electoral Board, the court held that the manner and method of service is merely directory. If you don't abide by the specific manner and method of service, that does not deprive you of jurisdiction to hear this case. As I mentioned at the initial hearing, doing so would deprive the objector of his due process right to have his petition heard if you could just sit on an objection as a local election official, not follow the procedures, and then the objection goes away. That's certainly not what is intended by the election code. It would be a constitutional issue, and the courts have said that exactly what the candidates are arguing is not correct here.
May I reply?
Yes.
The case law relied upon by counsel does not address the service of the objector's petition as I have quoted the statute. The case law that he cites, he refers to the service of the call. When you serve the call for the hearing, that's what those cases address. It's a different matter.
And that was my concern when we had our last meeting, as you know.
Right.
It was very
So,
much.
so on this, just three things to say. The first is, service of the documents on the candidates occurs pursuant to section 10-10 of the election code by serving them to the sheriff and by serving them through certified mail. And we went through the certified mail receipts on the last hearing. So they were served, and so the board has jurisdiction. The requirement under section 10-8 that they be sent a copy of the petition as well. The petition and the call were in the same envelope and sent to all of the candidates. So they were received. There's no evidence.
They were not false information.
There's no. So Mr. Morton, I believe, is also right about the Shipley case, which says that requiring the certificate of objection to be sent out within 2 business days, even the second business day, is a directory, and that did not take away the jurisdiction from this board. And I think that appellate court case means that this board should deny the motion to dismiss on these grounds.
May I highlight one other thing? It's in my response, but all of the candidates appeared, that have appeared by counsel have appeared before this board and subjected themselves to the jurisdiction of the board as well.
Mr. Cope, do you have?
Well, I mean, we didn't file a special and limited appearance because we generally follow the rules of the state of Illinois, which has eliminated that distinction. So I couldn't file a special and limited appearance solely for the purposes of objecting to jurisdiction. So I think that argument should carry no weight with this board.
Well, we all know how I feel because I did make that very strong statement of like, this is all about following the due process and the rules of what we're doing as being questioned, but yet we're not to question the process to get us into this room right now.
Well, that would be a separate issue, right?
Well, no, it's a separate issue. It's
I mean, how do we,
we're
how do
going
you
to
get past
follow.
that the nominations?
The rules weren't followed. The law was not followed.
Wheatland Township, right? I mean, there's like a non-starter, right? If you want to just do that.
I'm just saying, we're here because.
I mean, the nomination form said City of Naperville when it's for Wheatland Township.
Are we on to that one?
We already went on it, but I'm just saying. There's mistakes all around here, right? So if you want to talk about the mistakes of us, that's a separate issue than
Us?
the mistakes of this process, then it's a separate issue than what we're trying to deal with today.
But I would also add that there's an allegation that there was a mistake with the process, and that depends on what the business hours of the clerk's office were, and that is not in evidence. So as a preliminary motion, there's no evidence now as to what the clerk's availability was on Christmas Eve and the day after Christmas. So even if the objection
Christmas
warrant,
Eve,
Hmm?
they were,
Christmas
Christmas
Eve.
Eve, they were open, right?
we have no evidence of that before the board. And it's the clerk's office, not the township office, that is relevant. So there's no evidence in the record that it was actually late. Number one. Number
I'm
two,
sorry, quickly, Ed, but you can check the hours on the website.
but as the hours of the township are not the hours of the clerk, but
And none of that is here today.
Right.
None of that is before. us
that's not
today in
before
this
the board
room.
right now. But it doesn't matter, because even if it's late, the appellate court has
Because it's
said
not
that
before us, but it's general information available to every single person who wants to flip up in the website and check out. When is the highway?
I don't know if there are
Department.
Christmas Eve hours on the website. We would have to look, but none of that is
Well,
before us.
I
right
just
now.
wanna
None
know-
of that- None of that is here today.
Right.
But there's paperwork that shows what the
Right, but the
day off
reality
of
is
the
that
staff are.
even if it was late, the appellate court has said that that does not deprive this board of jurisdiction, and that is an appellate court decision that says that. And the second point that Mr. Morton made is that the candidates have appeared, so they waived any question of jurisdiction by appearing. And so while there's a lot of judgment on these motions left to the board, on this particular one, I believe that the board is constrained by the appellate court's decision in Shipley, which says that this is not a reason to deprive the board of jurisdiction, that the board should deny this motion.
Yes, do we have a motion to grant or deny the motion?
I'll make a motion to deny. Based on everything we just talked about.
Do I have a second?
Um, So we're saying that Mr. Copeman's motion to quash, we refuse it. That's what you just made a motion for.
His motion to
Based on what we
dismiss
just
the
did there.
objector's
Mhm.
petition because the certificate, the objection was not sent
In
by
a
the
timely
second
manner,
business day.
right? I make a motion, the opposite of what Anita just said.
I second
Which motion?
two Colleen's.
May I be heard before you vote?
You,
I'm just asking the board if I can say one more thing.
Yes.
You had mentioned your concerns over due process. The due process of you as the chair and the other electoral board members being able to hear this petition. If you move forward and you grant his petition to dismiss, where is the due process for the objector who had no control over how the candidates would receive any of the documents, how the electoral board would receive the documents, how anything happened after filing the objector's petition? That was all in the hands of someone else. What happens to the objector's due process then if you dismiss the petition? There's no coming back before you. That's the end of the story.
It's the same question as far why we were here on the initial reason, like, are you going to disenfranchise all the voters by taking away one side of the party they have an opportunity to vote for?
Well, you have an opportunity at the hearing on the petition to decide that issue.
Yeah.
But this is quite similar.
If I may, it's a very different issue because you're talking about a mistake made allegedly by the administrative aspect of the township rather than the candidates. What's alleged in the objector's petition is that the candidates made mistakes. And that question has not yet been before you on who's correct there, the objector or the candidates. All that's before you right now is whether the administrative processes were handled correctly. And if you dismiss the petition, then that underlying issue never gets to be decided.
I'd like to vote on the motion,
With the original motion,
the one that you just
Yeah.
seconded.
second, yeah, all in favor?
Yes,
Aye.
No.
Okay, so the motion to dismiss, based on section 10-8 is granted and the objector's petition is dismissed. The board is required to put its decision in writing in public session and sign the decision in public session. Because I did not know you were going to do this, I do not have an order prepared. So we'll have to recess and come back just for the signing of the order. So we want to suggest a time to do that.
Do we need 48 hours to be able to do that? I mean, could we do that sooner than later, than tomorrow? But I can't do tomorrow.
We cannot be, I cannot be here tomorrow. I can be here Thursday.
I can be her, sweet.
While you're thinking about that, just for the record, I'm objecting to the determination by the board. I just want to make sure that objection is reported. Thank you.
can you jump on your computer and type it up? I'll wait. Just kidding. I'm available, suggest a time that we need to come back. Thursday's bad.
I mean, if you wanna take a recess for half an hour and do it now, that's fine as well.
Works for
I
me.
would be
That's fine.
absolutely, yeah.
Right. So want to make a motion to put the board in recess for half an hour?
I make a motion to put this electoral board in recess for a half hour.
Second,
All those in favor?
Aye.
Aye.
Motion passes and we'll be back at 2:06.
back into
I make a motion to go back into session.
Second.
all in favor?
Aye.
Okay, we're back.
Aye.
Mr. Copeland would like to address the board.
Yes, at this time, I'd like to make a motion to ask the board to reconsider its vote. And instead of granting the motion to dismiss for the failure to comply with service under section 2-10-8, to take that under consideration and reserve ruling on that to the end. I'd like to ask that you, if you do not want to do that, I ask to withdraw my motion. Because I want to proceed and get to the merits as best, well, get on to the other motions. I
But
think-
why?
Why? It's my prerogative.
I wouldn't mind hearing it. Kind of motion, that's chair.
Hang on, I don't understand what's happening. We're
He,
moving on just for fun? I mean,
No.
we're already
Not for fun.
dismissed,
Well-
basically, right? So
Withdraw.
you guys voted, so we're gonna hear it and actually vote again, or what are we
No,
doing?
we're gonna withdraw. He's gonna withdraw. And I,
What do you mean?
that's fine.
If I may, I will tell you that if we proceed, if you stopped right here, there's a possibility for an appeal. If the appeal is granted, we'll be back here doing all the other stuff. And so I'd like to get the other stuff done while we're all here. At least all these meetings that are up today.
I make a motion to revisit it.
I second. All in favor?
Aye.
Aye.
No.
okay, so I just want to be absolutely clear what that motion
Do a
was.
redo, we can do a redo?
Hmm.
That's okay to just redo this whole thing?
The while the board is still in session before it recesses, the board can reconsider any vote that it's taken at any point.
Yes, okay, fine.
So I just want to make sure I understand the motion, that was just agreed on. So we're agreeing to, reconsider the motion to dismiss that was previously voted in favor of, and move on to the rest of the case without deciding that motion. Is that what?
Or did we just deny that? No. Did we retrade it?
That was what I wanted to do.
And mine's, I'm on.
Right.
It's the
No,
same
but
either
that's-
way.
It's a nice one, it's still here, right?
If you're retrade it,
Because-
you're retrade.
Because if what you're saying is that the board doesn't have jurisdiction and now you're moving forward to make a decision, that's conflicting with your earlier decision. So I think
Mhm.
you either have to deny the motion and move forward, or grant the motion and not move forward.
Or take it under advisement and reserve ruling to the end of the hearing.
On which? Both.
On the question raised by this motion.
Mr. Mullins' point, I don't understand how they would be able to consider something if they don't have jurisdiction to consider it.
That's the script. All right, so can you, I didn't understand your motion, so can you remake your motion? And clarify what we're doing.
Can we revote on the motion that we just took before we dismiss, before we adjourn?
Okay, so your motion is to reconsider the vote on the motion to dismiss.
Correct.
Okay, so is there a second for that motion?
Second.
And all those in favor of that motion?
All those in favor of that motion?
Now, is there a motion to, is there any other motion with respect to that motion?
To reconsider it?
Yeah, so now you're reconsidering it. Are you gonna
Right.
reconsider it now or are you gonna reconsider it later?
Now.
Okay, and so do we have a motion on that?
Motion.
I'm sorry, later.
Motion to.
What is the
Can't keep
difference?
retrading.
We,
Well, you either vote to deny it now
mhm.
or you don't vote on it and move forward.
If we don't deny it, then we don't have jurisdiction, so why are we moving forward? We just voted that we didn't have jurisdiction.
Mm.
So if we
Well-
do have jurisdiction, then let's vote to move forward, but let's deny that motion to dismiss based on the fact that we have jurisdiction, don't have jurisdiction.
Then we move forward.
Does that make sense?
Okay. So there's a second on that and all those in favor?
What's the I'm sorry, I don't understand.
The
What is the
motion
current
was to say the board has jurisdiction and move forward.
So in other words, it's a motion.
Deny the motion.
my motion.
Yes.
To dismiss objection proceedings.
Yes.
Okay, again, I would ask the board to reserve judgment on that and wait till the end. See, you've heard everything and then you can go back and you can decide.
But we don't have
All of them
jurisdiction. It's
Okay,
a no.
so-
Well, if you're admitting that you don't have jurisdiction. that's
Council,
fine.
council.
I'm not.
They're deliberating now. The argument is over. The motion is on the table. Is there a vote? On the motion to say the board has jurisdiction and move forward with the case.
Wait. So the end now? So we'll be able to go and revisit this, or we're not revisiting it and we're just gonna
That's
say
up
it
to you.
didn't happen?
This is the motion that's on the table is that you're finding that the board has jurisdiction and moving forward.
And finish.
To hear the rest of it.
To hear the rest of it, yes.
Okay.
Okay. All in favor?
Yes.
I'm gonna make an oral motion at this time. If I may make an oral motion at this time,
I object.
I would move that this board is irrevocably I won't add flowery language. This board has demonstrated by its actions at this hearing that they are biased and unable to have a an unbiased decision rendered in this case, as evidenced by the back and forth vote that just took place, by changing your motions based on candidates yelling things from the back of the room, and by your attendance at the Republican caucus that the product of which is at issue here. For all of those reasons, we would move that a new board be seated due to the bias hearing.
Well,
Wait, because this is, no, he's accusing me of being biased. You haven't even let me listen from day one. When this all went down, I was questioning this. Actually, Ed has been outstanding. He had reason, but I go back to my original point. That in fact, the reason why we're here is because certain rules were not followed. Well, this due process and how we got here, none of them was followed. Not Ed's fault. There's definitely been circumstances. So I have no idea what was even going to be argument. And I thought it would have been very irresponsible for me not to, in fact, agree with council on this, what they're talking about, that these rules and the law was not followed. Now, you have no idea. I have no idea. I have not heard your argument on where I stand on anything else. So can you please take all of those opinions and going in and throwing out a finger? Because we are here to get this done. I do still think there was not the law followed. But yes, I was very happy to hear, not gonna lie, because I want to hear these arguments.
But you voted against hearing.
No, I did vote against hearing it because I still believe that the process was not followed.
Then why did, if I may, why did you change your vote just
Because I
now?
want to hear your argument.
Why
I want to
didn't you
hear.
want to hear my argument 20 minutes ago? Why did you want to go against what the appellate court has said?
I didn't
Clear
go to law
precedent.
school, sir.
Well, you have an
I'm
attorney who's
sorry.
advising you.
Possibly.
And instead of using your attorney's advice, you're using the candidate's advice.
I'm candidates. What
Acting
candidates
on
am I
their
doing?
behalf. And that's the basis of my
Stop.
motion.
I can tell you to stop and I'm doing that.
she's the chair. I don't know. I'm just advising.
not doing that.
Ms. Hart is the chair that's been appointed by the Will County Court.
Stop.
So it's her.
I think the integrity of the process was questioned with the timestamp. And it seemed, but I don't know, once we took a break there, I just felt like I would rather hear the full case. That's my comment.
So
I do want to hear.
there has been a motion made to disqualify the board for bias. The board does not have to
Entertain that.
that motion. It hasn't been written and the rule is that it needs. But it is in the record.
And so the board is not taking action on that motion.
I'm said that they.
Nor should they.
They have every opportunity if they would,
Would anyone
someone
like to
would
make a
like-
motion to do
if someone,
this?
if someone would like to make a motion to disband the board, they are welcome to make that motion.
I'll make a motion to disband the board because I think we voted. And I don't understand why we would do a retrade. I don't understand.
I've not had. the
Is
opportunity to hear them.
is there a second? No second, so the motion fails. Do you want to move on to the next item on the agenda?
And of course I object for this.
What's on next? Thing which I do apologize, but then I'll have to go back on that since we had a curveball.
So we
Or not
have
to-
resolved the two motions,
Right.
and what is before us now is Mr. Morton has filed,
Because for issue subpoenas,
The two
taking the
subpoena,
reasons
yes.
for the board issue to issue the subpoenas.
so, Mr. Morton, I did not see in the documents that you filed a request that the board issue the subpoenas and an explanation for why those subpoenas are necessary. Is that something that you had filed?
The email itself labels it as a request for subpoena. That is the written request for the subpoena. As for the reasons for it, it's evident within the subpoena, the reason for requesting them, narrowly tailored as they
Okay,
are.
I just wanted to make sure that something had not
Something had
been
not been
inadvertently filed, okay?
What
So-
needed to be filed was.
Now you have the floor to make your request. to the board.
Objection, he never filed a request. I filed a motion to strike
I-
him because he didn't file a
I
request.
understand that.
And now you're allowing him to
No,
make the request.
he-
That's improper.
No, he is going to make his request and you have the opportunity you filed a motion to quash and you filed a motion to dismiss. And you'll have the opportunity to argue both of those. Mr. Morton.
Thank you. First is, aside from the subpoena issue, we have the request for production of documents. There's nothing in your rules covering the request for production of documents, other discovery. This was brought up at the initial hearing with the board, and it was discussed that if there were any discovery requests that were to be made, they should be made by the 10th, and that's what we did. We filed the request for production of documents. So I don't
Was it
see,
included in the filing?
yes, it was.
Yes, and you have a copy of that.
Okay.
Yes.
So any of the, well, I'll respond to opposing counsel after he makes his argument, but just for the sake of the request for production of documents, what we're requesting here is again, very narrowly tailored as to elicit information that will, it is extremely narrowly tailored to elicit information that is directly related to the contents of the objector's petition. All we are looking for truly is information about who maintains the records that are pertinent to this case. If one of the candidates maintains these records, then they should produce the documents that are related, relevant, germane. If not, then we ask that they identify who that person is, so that person can be requested to produce those documents. Those documents speaking to our
Can I
underlying.
ask you to take a step back?
Sure.
Explain what the documents are that you're asking for and how those are related to the claim that you're making in the objection.
So the objector's petition claims three things. One is that the city of Naperville is listed as the actual body governing the nominations. Second is that one candidate didn't file the required qualifications. And then the third issue, which is the issue that's relative to our discovery request, is whether there were additional qualification requirements put on the participants at the Republican caucus. Our allegation in the objector's petition is that there can be no additional qualifications required. There is evidence that was presented with the objector's petition, just one piece of evidence. We're looking to see if there is something more substantive in addition to that. For instance, the rules, the draft rules, the adopted rules of the caucus would possibly identify whether there were disqualifications as to who could participate that are not allowed by statute. That's why, first and foremost, we're asking to produce all draft and adopted rules of procedure for the caucus. Again, if none of the candidates have those rules, then we would ask them to identify who has created or possesses that. Then we ask for a limited time frame, September 1st to December 3rd, so a 3-month time frame of correspondence sent by the Wheatland Township Republican Organization referencing specifically participation requirements. We're just looking for anything about what was required to participate in the caucus. The same thing with any other documentation other than correspondence that would be in the control of the candidates, and evidence of who administered the Facebook page for the WTRO, because the Facebook page is where that one document attached to our objector's petition comes from. So knowing who published that would help us then gather more information about whether those were actual disqualifications or not. The point of this is, if there were no disqualifications at the caucus, if this was not something that actually happened despite the Facebook post, then there would be no basis for the objection. But we don't have that information, and that's why we're requesting.
And that's related to the written discovery, and you wanna,
Yes, and
I think we should do the subpoenas at the same time.
Sure. So the subpoenas, that are being requested as emailed to the board's attorney and to opposing counsel, labeled a request for subpoenas, are to Raquel Mitchell and to Kimberly Lawfrey, the presiding officer and the secretary of the Republican caucus. Those two individuals, as they signed the certificate of the candidates of nomination following the caucus, reasonably, we believe that they would have the documents that we're seeking. The draft and adopted rules of the caucus, as well as any correspondence sent by the caucus, that sort of information. So we are asking that they appear before the evidentiary hearing and produce the documents that are, again, very clearly laid out here, which references or relates to participation requirements for the Republican caucus. That's all we're looking for here. We're not going on a fishing expedition. We're not trying to get every document under the sun that belongs to the Republican Township organization. We're just looking for things related to the participation requirements for the caucus.
Mr. Copeland.
Sure. This is ridiculous. I've been doing election law for 20 years. I've never seen anything like this. Request for production in a proceeding such as this. It's absurd. And I'll tell you why. Because all it does is harass and delay. It harasses the candidates. It harasses two people who aren't even here. They're not candidates. And all it's doing is attempting to delay these proceedings. Do you think that you could go home and figure some of this stuff out within a day or two? Do you really think you could do that? Because it takes time. And most people have a full-time job and don't have time to be messing around with this. But what I will tell you is what's extremely frustrating is that when council says that they're narrowly tailored, he's looking for 3 months. Think about going back and looking through 3 months of emails. And if you have more than one email account, you got to look through 3 months of emails on more than one account. It's overly burdensome and it totally violates and is against the spirit of the rules that you adopted on the first day you were here. I have filed a motion to quash this request for production. I filed a motion to quash these subpoenas, and it's for good reason. You have my motion. I hope you've read it. If you haven't, I ask you to read it. And what I will tell you is that all of this relates to the third part of their objection. They have 3 parts. One is, they say City of Naperville, not Township of Wheaton. Number 2, Bruce Dorada didn't file his qualifications to work as an assessor. And number 3, we think they had this rule. They don't say we think they had it. They don't say upon information believe. They say, they had this rule at their caucus. And if with this rule, it denied people from participation. But now you hear him say, we don't know what the rules were. That's what he just argued to you. We don't know what the rules were. That's why we need to see all the drafts. We need to see all the rules. The problem with that is the petition that was filed is verified. If you look at the objector's petition, I believe it's page 4. This is a verification. Okay? It's notarized. That means the objector was sworn to and said, everything in my petition is true and it's in my personal knowledge. That's what it says. If it's in his personal knowledge, he doesn't need to do this discovery because he has evidence. He can come in and testify to you. He can be put under oath, sworn in, and say to you, they had this rule at the caucus. Well, if they didn't have that rule at the caucus, or if he doesn't know if they had the rule at the caucus, then he's committed perjury or false swearing by signing this verification. And if he does have that information, seeking all of these documents, seeking to pursue the subpoena and look for all these documents, that gets after what we call cumulative evidence or repetitive evidence. And it's stated in your rules. You have discretion. You have discretion to exclude and keep out evidence that would be cumulative or repetitive because we're on a short time frame, right? The clerk, she sits on your board here. She can tell you when she has to certify the ballot, certify the candidates to be named on the ballot. I believe it's the 23rd. I could be mistaken. Maybe it's the 24th, but it's right in there. So we're supposed to get all of this, come back and have a full evidentiary hearing on what is presumably cumulative evidence because you have a signed and verified objector's petition. It says, I, David A. Pigeon, being first duly sworn upon oath, depose and state that I have read the above foregoing objector's petition and that the matters and facts contained therein are true and correct to the best of my knowledge and belief. Okay? He says they're true. He's sworn to it. But now he said, well, I don't know if that rule was really there. And I need them to prove that rule is. That's not what he stated in what he filed with the clerk. So to allow this discovery, to allow the subpoenas to issue, can only do one thing, and that's harass the people it seeks the information from and delay these proceedings even further. And the last thing that I'll point out, the petition where it talks about these issues are paragraphs 12, 13, and 14 on page 3. And what they say, that they make the argument that there was an additional disqualification of young voters not permitted by the township code. Yet nowhere have they cited any code that says, any statute that says you can't have this limitation on participation. There's no statute that says you can't limit participation based on voting in primaries. Okay, and I'll be honest with you, I would never expect to find a statute like that. But what you do look to is case law. You look at the courts, you look at the appellate courts, you look at the Supreme Court, you look at the written opinions.
Objection.
He has
You're
not
arguing the
cited-
petition here rather than your motion right now.
He hasn't cited to a single case that would indicate that this is against the rules.
You've not
So
made,
therefore-
you've not made a motion to dismiss based on the plea. But that's what you're arguing right now.
Counsel.
You're welcome to respond when he's done, but
Well, I'm trying to cut short an argument that is improper.
Counsel, this goes to relevance, okay? This information is not relevant because he can't show that it's against the law. If he can't show it's against the law, it's irrelevant. So tell me how that could be not with the intention of delaying and harassing. When even if he gets the information, even if he shows it, even if he proves it, it's not relevant because there's no law against it. I think it's pretty clear that it is a fishing expedition because apparently Mr. Pigeon doesn't have the knowledge, even though he verified his objection and said he did. It is a fishing expedition because they don't know what the rules were. They're hoping to find out what they are. And even if they do, they can't even show that it's against the law. So it's irrelevant, it's improper, it's brought for an improper purpose, and therefore the motion, the request for issuance, and even though it was never put to you in the form of a motion, which is what I would expect, even though nothing was put in writing requesting that other than an email, hey, here's our request for production, here's our subpoenas. I think all of that should be denied, the request for it, and my motion to strike and quash those items should be granted for the reasons I've stated. And I appreciate your attention to this matter.
are you continuing to maintain or withdrawing your motion to dismiss on the grounds that the request for subpoenas did not abide by the rules?
I'm continuing in that because
Okay,
At
you
no
just
point-
didn't address that.
no,
so I wanted
and
to-
I appreciate that because I mean it's addressed in my motion.
Yeah.
But nothing was ever submitted to this board that stated why those subpoenas were needed. And your rule on subpoenas, I think it's 11. Bear with me one moment. Oh, no, I'm sorry. It is not 11. It is 9. The request for the issuance of such a subpoena shall be made to the electoral board in writing and shall identify the person or entity being subpoenaed and any materials requested pursuant to the subpoena, the purpose of the subpoena, and a statement describing why the subpoenaed person and or materials are relevant to the proceedings. That was never done. So you haven't complied with the rules, you haven't complied with this I'll conclude my argument with that. Thank you.
First, in response to his wanting to dismiss the entire petition on the basis of a rule allegedly not be followed. As you heard from me,
We're not to that motion yet.
I thought that's the motion that he just brought up to you. Is it?
Well, then I would like to argue that
that's-
motion. I'd like to argue that
Are we
motion.
motioning just to wash the subpoena request or is there?
Are we just dealing, yes, are we just dealing with that?
Yes.
Okay, not the motion to dismiss the objection proceeding.
Well, he addressed both of those in his, so you can respond to whatever he.
I will apologize. I was not addressing this motion yet.
Okay, then we can
Okay.
go one by one.
Thank you.
So back to me.
Yes.
Okay, thank you. So on that issue, again, for the reasons I stated, we requested in the email that the subpoenas, we requested the issuance of the subpoenas by the board. We also explained within the subpoenas their relevance as it pertains, you look at the objector's petition and the subpoena request, it's clearly about the participation requirement that's laid out in the objector's petition. So we believe on that basis that we have complied with the board's directives. Additionally, when we were talking at the initial hearing about the submission of discovery requests, the subpoenas were lumped into that discussion. And so based on what was discussed at the initial hearing that Mr. Copeman's colleague attended, this is what was expected, that these documents would be brought forth to you, these requests, and that you would then decide at today's hearing.
Wait, I'm sorry, can you go back to that? I didn't hear anything of that way in our last hearing. Did I miss that?
At the end, yeah, he asked, how we were gonna
He
handle it.
asked at the first meeting how to do this and whether the board wanted to set a deadline, and I said,
We did.
just make sure that you have it to us so we can consider it by this
The
meeting.
yes.
We
Subpoenas.
put a time on it. We
Correct.
put a time on it.
The subpoena request and the production of documents request. Regardless,
I guess I thought you were bringing like evidence, because I feel like the one thing that just really resonated with Mr. Coleman is that we have a short period, so I don't know how we're going to, like, I love my civic duty and I love coming in and doing this. I don't know how much more time. So what are we doing here? So I thought you were bringing that. I think that's where, I'm sorry, I apologize. I thought you were bringing in, but you're right. So,
if I could issue the subpoena myself, I would have, but the board has to issue the
well, you
subpoena
didn't,
for the
couldn't you have
documents.
asked last time or no?
No, they had to be, there were no rules of procedure yet. The board hadn't convened yet. It had to have happened between your initial hearing and then the date set for today.
Is there someone, can I ask you this? Because again, I had to kind of like look up this and was there someone that was making a complaint that was not able to vote? Is that what happened? Or I don't even know how this like kind of came up with like I saw that. I've been wanting to ask this for a while now.
If I may, that's not the subject of this request for documents, though.
So isn't that what you're looking for? No.
We're not looking for any documents about the individual participants other than whether they signed an affidavit that they participated.
So
The
you're
the
just
caucus.
looking at the rules.
the rules and I didn't mention earlier, but it is contained within the request, affidavits of the participants in the caucus, whatever they signed to participate, because that also could state on there, I am qualified based on the fact that I participated in 3 of 4.
I have them right here. You can take a look at them. These are the affidavits of the people who attended the caucus.
Oh, so you did it. So that was the whole thing to bring in the affidavits for this.
No, but
No,
he's offering it.
Oh,
I'm
okay.
offering it
So
now.
that's what you need. So
And the rules, you have the rules as well?
I do not.
Okay, so
okay,
then
can't you just go on the website and look at the rules?
I don't know that the rules that were actually adopted at the caucus are what would be on the website. That's why we're asking for whoever has the possession of it would provide it.
Did you ask someone? Like, can they just bring it? Like, this is not,
What's the payments for?
well, can't they just produce it?
And if they say no, then I would come back to the board and ask you to subpoena them at that time. So we're right back to where we are.
So you'd like more information on everything you just laid out. And Mr. Copeman, you're saying that this is irrelevant because Mr. Pajan has already assumed that the rules for the caucus went off as they should have or whatever, and that he's contesting something different. So this is irrelevant? Is that what you're saying?
Partly,
I understand
yes.
what you're seeking.
Yeah.
If I could respond to that, but you can.
Yeah, partly. So yes, he's asking for certain items, but he's provided a sworn to objector's petition where he's asserted that those are fact. And in your rules, which were adopted last time, there, in many places, it says we need to move forward, we need to get things done quickly, it's an expedited proceeding, and it talks about if you want a subpoena, you have to make a request and you have to state why you want that subpoena.
Mhm.
That wasn't been done, that hasn't been done here. So he hasn't followed your rules, so that's a reason for denying the subpoenas, first of all. But secondly, it also would be cumulative or redundant to allow him to issue those subpoenas, because as he's asserted in his objector's petition, which is verified, he says everything that's contained here is true and correct based on my knowledge. Well, if he has the knowledge, that's evidence. Testimony, people coming in, swearing, giving testimony, that's evidence in and of itself. So that would be, getting these things would only be cumulative and they're only delaying the process.
Mr. Mullen, and I don't see the purpose of this proving anything. I would
I'm
like
sorry,
to
can I
get
finish
to
my
the
response?
actual the meat of why this is all seems like
Right, I understand.
Gravy.
What Mr. Morton is trying to do is to get the information that is in the possession of the other side that he thinks he needs to make his case that the law was violated.
mhm,
And so he's coming here and asking you for permission to try to get that information, right? So that is not unusual. We do that all the
Sure,
time.
sure.
I was spending my hour before coming here writing a request for subpoenas in a residency case in Thornton Township, so it is not unusual. And it doesn't make the proceeding,
just
go
seems
on
like it
forever.
takes us
So
down a
it's
different
not at
road.
all. It takes you down a different road. Now, there are three things in the objection. One is that the assessor didn't file his certification. None of this is relevant to that. The other is that
Wording.
the certificate of nomination had the city of Naperville.
Correct.
And in my opinion, none of this is relevant to that.
Correct.
Okay, so there's a third objection, which says that the
Well,
Township Republican Party put in a rule that said you had to vote in 3 of the last 4 primary elections in
Okay.
order to be on, to be able to vote
okay,
at the caucus, right? So they're challenging the legality of that rule
Mhm.
because the township code says that you have to say that you didn't vote in the last election, not the
Mhm.
last 3 elections, but just the last one, right? So that they're arguing that it violated the code.
mhm,
Now, I disagree with Mr. Copeman on what the objector is verifying, because he's not verifying what the rules said at the actual caucus. What he's saying is that the notice said that this rule, and so what Mr. Morton, I believe, is trying to get information about to give to the board is what the actual rules of the caucus said, so that he can show that the caucus rules were invalid.
It's right
So-
there, isn't it?
So so this is the notice and he's trying, and the person verified that that's what the notice said. And now he's trying to say that the actual rule at the caucus was what the notice said the rule was going to be. And he wasn't at the caucus, so he doesn't have that copy of the rule, so he's asking for it. Now, there are procedural issues about how the request was made, the extent of the subpoenas, all of that. It is my opinion that if they have the rules of the caucus, that is something that would be relevant to the board and should be produced. I don't have an opinion on the rest of it, but I think that it is not sworn here what the rules were at the caucus. What is sworn here is that the notice said this would be the rule at the caucus. And so I don't believe there was any issue of perjury. And I think that Mr. Morton is entitled to see what rules were actually adopted at the caucus, if any of the candidates have that in their possession. As for everything else, that is completely your judgment call on whether or not you allow it. But I think the one thing that I think is normal to provide
mhm.
is the rules that were adopted at the caucus, and that should not be burdensome for anyone, and it should not take any additional time. Everything else, it's up to you to decide, but I think that one piece of information is definitely relevant and should be provided if it can be.
I just don't know why you have to, I guess my whole thing on it was why you have to subpoena it. Why can't we just, someone produce, why don't we just go online and look? I
And
mean,
if I may, what we have in our objectives petition, right, is this notice, right? If jumping into shoes, predicting what might be argued at the evidentiary hearing, Well, that's not the actual rules. The rules are what matter. But then if they never produce the rules, how are we going to counter that? So we need the rules to be able
Why do you
to
have to
show.
subpoena? Can't you just ask for the rule?
We have in our request for production, that's what we've asked for. The subpoena is if the candidates, because we can only request production from the 9 candidates. If the candidates don't have the adopted rules, then we would need to go elsewhere to acquire
So
them.
the guy that, the objector, right? So I'm going in, I'm gonna object, however you're thinking, whatever, I'm all about everyone should just go to election day, but you're going in, you're doing this. He didn't go and print any of that when he went and looked at the rules? I mean, that's, I guess I'm just trying to feel like this isn't Perry Mason. Like, why, this is simple, we're in a township. Why these aren't there? I mean, if you're looking at those, I mean, I'd rather talk about the law, that I don't know what that law is, if you can, you know, how that's
If you want
going.
to see the rules, then let's have them produce it.
Why
If
don't you
one of the
just ask
9
for it?
candidates has them, then we'll have the rules, or we can subpoena the presiding officer or the secretary, certainly the secretary would be required to have the adopted rules. There's no verification of, you're referencing rules that are online. There's no verification that that's actually what was adopted and used at the caucus. That's why that's what we're requesting.
So Mr. Mullen, do we have to make a motion to, I am interested in seeing.
So
the rules.
we have 3 motions pending
That's what
by
I
the
thought.
candidate, not the board hasn't made any motion. But
Correct.
the
But there's
parties
3 on
have
the
3
table.
motions. One motion is to grant the discovery.
Mhm.
The other motion is to quash the discovery, and then the other motion is to dismiss it because the request for discovery didn't comply with the rules. And those are the 3 things that the board has to decide.
Dismiss
So-
the whole case.
Hmm?
Dismiss the case.
Dismiss the request
Or just the
or
request.
Right, so
request.
the board has 3 motions. One is the request to issue discovery,
Mhm,
and that's 2 subpoenas and the written discovery.
mhm.
There's a motion to quash that. And then there's a motion to dismiss for failure to comply with the rule about how to ask for subpoenas. Okay, so those are the 3 motions that are pending before, the board hasn't made a motion, but those are the 3 motions that the parties have made to the board, and the board has to rule on all 3 of those motions or take it under advisement and rule later. But eventually the board has to rule on all 3 of those motions and vote on all 3 of those motions. You do not have to grant or deny the motions in full or in full. You can grant and deny them in part. So for instance, you could make a motion with respect to Mr. Morton's discovery and order the candidates to provide a copy of the adopted rules. You could deny it outright, you could grant it outright and have all of the discovery served. So you have options, right? You can say nothing, everything, or you can limit it to what you as the board would like to see in the argument. Right. With respect to the motion to quash, that's the mirror image of the motion for discovery, right? So if you give Mr. Morton everything that he asked for, you're gonna deny the motion to quash. If you give Mr. Morton nothing, you're gonna grant the motion to quash. If you give Mr. Morton something but not everything, you're gonna grant the motion to quash in part and deny it in part, and it's gonna mirror image what that ruling was. So what you as the board have to decide is what evidence that Mr. Morton does not have, that the candidates have, or other people in the township Republican organization have,
Mhm.
that you believe should be required to be given to Mr. Morton so that he can make his case that the rules violated the code.
I'd like to make a motion to allow Mr. Morton to pursue the rules of home caucus, but nothing else.
Okay,
I second.
Yes, all in favor?
Yes.
Motion carries.
okay, and
Yeah, I was just gonna say, if I could request that my motion to strike or quash the objector's discovery and subpoena be granted, except for that part.
okay, and that would be the mirror image of what you just moved. So grant all of the motion to quash except the request for the rules.
I make a motion to grant all of the quashing, can that be a verb?
It is.
Except for the one item regarding the rules.
If I may, just I wrote down the wording of the first ones for the.
Please help me out.
So you would be to motion to grant the candidate's motion to quash in part, except to
Oh.
pursue the rules of caucus.
Thank you. I have to repeat that?
No, so moved. Second,
Second.
all in favor?
I.
Okay,
May I
Do you-
have a
Okay, I think I
clarification
need
on
to
that?
say that.
That's just a production, not a subpoena, correct? So we're
Correct.
not
Well-
going through the process.
well,
of
he is
issuing
allowed to, if one of the candidates have a copy of it
Correct.
and can give
I
it to
will-
him, then we will resolve this.
I'll
If
figure
not,
that out before I leave today.
okay,
Or if testimony would elicit the rules of procedure, that is pursuing the rules of the caucus. So it would apply to that as well.
so all of the motions that have been filed have been either granted, denied, or taken under consideration by the board. Now, the question
Not yet.
is,
There's one more.
which,
It's a motion to dismiss objector's petition for failure to abide by directives.
sure you wanna proceed with that?
I am.
Okay.
I want to make a record of it. It's
Well,
filed.
you can, you can make, it's in the record.
Mhm.
Go right ahead.
Yeah. Okay, file the motion of failure for a motion to dismiss the objector's petition because they did not follow the rules of this board. The first is that they did not bring a written request for subpoenas before asking that they issue, and they would never ask for leave to issue the written discovery. That's the basis of my motion, and under your rules that have been adopted by this board, I believe it's Rule 10, you can dismiss the objector's petition for failure to adhere to the rules. So that's my motion.
So just for the record, there is nothing in the rules that relates to the written discovery, the request for production of documents, and we did tell Mr. Morton at the initial hearing that he could serve those. So I don't think, I understand you were not here at that meeting, but that is what was told. So the question is, Mr. Morton's request for subpoena was sent to me as an email, which that attached the subpoenas. But in my opinion, did not have an explanation other than the subpoenas themselves. Mr. Morton today explained why he wanted the subpoenas. That was not, I did not see that in the documents that he sent me. So the question is his failure to
Explain why you wanted all of that.
a reason to dismiss the objection
Entire.
entirely, and
Okay.
I believe the proper remedy is to deny the request for subpoenas, not to dismiss the objection in its entirety for violating that rule, if you find that it was violated.
Can I ask you a question?
Yes.
So if we decided to do that, is that then again grounds for appeal and we're right back here
Yes.
again?
Well, if I may address the board. Whatever your decision is on anything, all of it's subject to appeal. And we could all end up back here. So
I mean,
at
not
the
that I'm not
end,
having a good time, but yeah.
right, at the end, I mean, at the end, whatever your decision is, however you get to it, all of it is subject to appeal.
Yeah, it's just some seem easier than others, yes. And, you know.
May I briefly respond?
Yes.
In terms of the rules and what they provide, Rule 10 says may be grounds. So it's certainly not a requirement that if you believe that a rule wasn't followed, that you would dismiss either the requested documents or the entire petition, which would be an extreme result. And as was pointed out, would bring you right back to where you were a little while ago. Secondly, the only motion up right now, just to clarify, is again, the dismissal of the entire petition based on failure to abide by the rules. The subpoenas and discovery requests have already been settled.
So do we have a
Mr. Mullen? Oh,
yes.
can I ask? So we verbally gave different instructions regarding subpoenas that are different
It
than?
was not different instructions regarding the subpoenas. written discovery is not specifically in the rule. The way that electoral board proceedings generally work is that you look to the rules of the circuit court,
Okay,
where the jurisdiction is for anything that's not in the rules of procedure. So it is not uncommon to serve written discovery. There is a rule that relates to what we call a notice to produce, where we give the party a notice and we ask you, when you come in for the hearing, we want you to bring these documents with us. And there's not a provision in that specifically under the procedural rules of the board, but that is standard because that it incorporates the procedures of the circuit court. So it's not an unusual thing. So we did not say anything about the subpoenas. We just said that, you know, we wanted to issue written discovery to do that before this hearing so that we could address it.
Yeah, I guess and I apologize. I really thought when we had talked about it, I thought you're like, oh, because I do remember you're like, this will give me time. And I thought you meant to get this information that you're now asking, like. I thought really this was gonna be like you were going to bring everything.
Right.
Today.
So you have a motion now before you to dismiss the objection on the grounds that that the objector did not comply with the rules and asked for the subpoena correctly.
which would eradicate
And-
us asking for the rules in the previous motion, correct? Like we are allowing
You're
them,
allowing that.
yeah, but if we vote negatively on this one,
Then the
whole
objection is
is-
dismissed and we all go
yeah.
home.
it seems like we
And-
did that backwards.
Yeah.
But anyway, okay,
We did do that.
no, it's in order.
But we don't have to take this motion, do we?
You do not have, you do not have to decide this until you're ready to decide it. I mean, you have to decide it eventually, but you do not have to decide it right here and now. So those are the motions that were filed in writing by the
Mhm.
board today. Mr. Morton has the burden to prove his objection. And normally we would have another session where we would have them possibly provide the legal arguments for the substance of the case, which we haven't gotten to yet. Or you could move forward and ask counsel if they're ready to present today. And other than, you know, that's up to you. And counsel,
I just asked these gentlemen or I have to make a motion
you can ask
I'm ready to
to
proceed.
the attorneys, yes, are
and
you
ask
ready?
them what they're
I wanna get it
prepared to
done.
do and what they would prefer to do.
Yes. Mr. Morton, would you like to comment on what you're?
Yes, since we have a discovery request that's pending, that was just granted, we would request a few days to actually have that
Mhm.
document produced and a chance to make sure that we have the case that we need to move forward based on those documents. It seems like it would be, I don't understand the reason for granting discovery, the ability to go get these records without then giving time to do so.
And I would like to ask the board to tell me what you're gonna do with this motion to dismiss. Are you tabling it? Are you reserving decision on it? Or are you gonna grant or deny it today? I'd like to know what you intend to do.
I make a motion to table the motion to dismiss based on not following the rules for the.
If I may, I think improper language should be motion to take it under advisement, not table it.
I amended to take the under advisement.
We'll second that.
All in favor?
Yes.
Yeah.
So do we want to set a time to come back? Does next Tuesday at 1 work, or do we want to come up with a different time?
Tuesday at 1 would be fine for the effector.
Do we have to wait a certain time? Can we just rip this up like a Band-Aid and come back tomorrow?
We have,
One day. I think there's a Friday.
I could not be here tomorrow.
Thursday morning,
Thursday, I could be here.
Thursday morning.
Does that, but Mr. Morton needs enough time to get a copy of the adopted rules.
If I would suggest that if we're setting it for Thursday, that we set it as status on discovery and proceeding on the petition if discovery's been complied.
I don't know why we just can't get someone to go into the rules right now.
Thursday morning at what time?
I mean,
I'm only available Thursday, like I'd have to be out of here by noon.
And I can only do it in the afternoon, so I can do
Yeah.
anything Friday.
Friday also works.
I'm in court at 9:30. It's on Zoom. I could do the Zoom here and then start after court, but I think it's gonna be canceled because the Attorney General is intervening, but it's
This is Friday you're talking?
Friday, yeah.
I do not anticipate this being a long argument for any of the 3 points that are raising the objection.
I can do Thursday then at like 9 a.m. Oh, so sorry,
Well, I can
Anita.
do- I
You
mean, I
said
can
that.
Zoom in.
I'm not thinking.
Okay.
what time can you do on Friday?
I can make anything work on Friday.
Oh, it's not, but not tomorrow.
I can't do Thursday morning, I
Oh,
can do
Thursday morning,
Thursday
I'm sorry.
afternoon, and you can't do afternoon, right?
I cannot do Thursday afternoon.
Friday afternoon,
I can do anything.
then noon on Friday, because I'm supposed to be at a conference, but I can go back and forth to Peoria.
Noon on Friday works. for
What's
me.
the suggestion then? What time on Friday?
You guys choose. I'm available.
We can
anytime.
do noon on Friday.
May I ask if we could do 1 o'clock on Friday? I do have a conference call scheduled for noon. I'm sorry,
That's fine.
but I can do that from the parking lot. I just need good time to do that.
Cold out there.
I'll keep the car.
Oh, yeah.
Okay, so we'll set this for noon on
1
Friday,
p.m.
1 p.m. on
1
Friday,
p.m.
for a hearing on the merits of the objection. Do we have a motion? Motion to set the hearing for 1 p.m.
On Friday, the whatever it is, 17th.
17th.
Second,
All in favor?
Yes.
Motion carries.
motion carries. Public comment.
Public comment?
Is there any public comment?
Motion to adjourn and motion to recess until Friday at 1.
Make a motion to recess until Friday at 1.
Is there a second?
Second.
All in favor?
Am I?
Carries.